I would also like to thank Dean Peñover, Dean Miner, Dean Peck, and everyone at the Office of Judicial Engagement for their continuous support throughout the competition. I'd like to thank our incredible faculty advisor, Professor Bloom, and all of our faculty judges, Professor Atlas, Clopton, Whalen, Reklinski, Chutko, Goldberg, and you're amazing. Thank you for judging the quarterfinals and the semifinals and providing the most support while we were drafting the problem and writing the bench memo. It was essential to make the competition as challenging for the competitors as we possibly can. I'd like to thank the outgoing board for their guidance and assistance. If it weren't for you, Langfan would have been a lot more painful than it was, so thank you. To my current board, the Laurens, Catherine, Kate, Samriti, Ben, Gabrielle, it's been a pleasure to work alongside you. Thank you for your tireless effort in putting this problem together, the bench memo, and the competition itself. And finally, I'd like to thank all of the competitors. We were extremely impressed with the quality of the rounds this year. We hope you had fun arguing this problem, and we hope you come back for upper class competitions and apply for external competitions. Moot Court is one of the most challenging, but absolutely one of the most rewarding extracurricular activities that you can possibly do in law school. So please come back. Now I would like to announce our esteemed panel of judges for the round today. Serving as our Chief Justice is the Honorable Colleen McMahon from the United States District Court for the Southern District of New York. And serving as Associate Justices are the Honorable Marcia Peckman from the United States District Court for the Western District of Washington, the Honorable John Kronstad from the U.S. District Court for the Central District of California, the Honorable Thomas Wheeler from the U.S. Court of Federal Claims, and the Honorable Ellen Bendix from the California Court of Appeals. Arguing for the petitioner today, the Myron-Stennis State Park and Planning Committee, is James Pinchak. And arguing for the respondent, Frank Rossitano, is John Mucciolo. I congratulate the competitors and wish them the best of luck. I hope we have a phenomenal round for you today. Thank you.
Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the Court is now sitting to hear the matter of Myron-Stennis State Park Planning Committee against Rossitano. God save the United States and this Honorable Court.
Ladies and gentlemen, you may be seated. Welcome to everyone, and especially to Mr. Pinchak and Mr. Mucciolo. Counsel, you can rest assured that we have read your superb briefs, that we are well acquainted with the issues, that we will have many questions for you, and we look forward to hearing your arguments. Mr. Pinchak, I believe you have reserved 1 minute for rebuttal. Is that correct?
Yes, Your Honor.
Thank you. You may proceed.
Madam Chief Justice, may it please the Court. This Court should reverse the holding of the 13th Circuit and decide that a 94-year-old war memorial commemorating the lost 49 lives of St. Jana County residents does not violate the Establishment Clause of the United States Constitution. To hold otherwise would undermine the principles of the Establishment Clause, which are to stop social discord in the community, as well as stopping the government from endorsing religion or
I thought that the purpose of the Establishment Clause, Mr. Pinchak, was to keep the government from establishing a state religion.
No,
Not the I never heard about the social discord part.
Your Honor, directing your attention to Justice O'Connor's concurring opinion in both Lynch and Panett, Justice O'Connor noted that social discord is a problem in the community when certain religious either practices by the government, like active practices, make people feel like they're outsiders in their own community. It creates an insider-outsider game, for instance. But that is just one purpose of the Establishment Clause. The second purpose is to stop the government from active endorsement, endorsing one religion or the religious enterprise. Now, when evaluating the monument in today's...
How's a 40-foot monument in the middle of a public intersection demonstrating government neutrality, which is what you're trying to describe?
Your Honor, I would direct this Court's attention to Justice Breyer's concurring opinion in Van Orden, which doesn't just ask whether or not a monument has some symbolism of religion, but rather how it's actually being used, not whether or not it could be used to endorse religion, but is it actually being used to endorse religion in this case? Not whether it could cause social distortion in the community, but whether or not it actually is causing those social issues in the community.
Well, Mr. Pinchak, what about, how is that to be assessed, given that some of the people who observe this just are driving by?
Well, Your Honor, in this case, there are numerous secular elements right outside and nearby this cross. For instance, this cross and this war memorial stands in a veterans park. There's a sign for people who walk by that says that this is a veterans park.
Is it well maintained so people can see it? And how do the drivers see it?
Your Honor, the drivers can see the cross, but what they could also see is a private emblem at the very top of the cross, which could be seen from hundreds and hundreds of feet away, which shows that this is sponsored by a veterans association, a secular element. Just like the private logo that was on, for instance, the Ten Commandments in Van Orden, which shows that there is some secular element.
Yes, but the Ten Commandments is a symbol that is very much a part of the history of the law, all right? So that when you see a Ten Commandments monument in a courthouse or in a public square, in a legislative building, you at least have the reference to a secular law-giving function. I'm not familiar with the secular function of a Latin cross. It is the ultimate symbol of Christianity.
Chief Justice McMahon, I think there are a couple factors that should be looked at here. The Ten Commandments have commandments that aren't necessarily codified in American law that are just inherently religious. The first commandment on the Ten Commandments in Van Orden was, "Thou shalt not worship any other god but me." That was found to be constitutional in Van Orden. "Thou shalt observe the Sabbath." Those were commandments that were not codified in American law. Here, there is...
Really? As blue laws? Very much codified in American law throughout a long period of American history.
Yes, Your Honor, but it's not codified at this moment, and that did have more of a religious connotation and symbolism than the cross has in this case. For instance, comparing "thou shalt not worship any other god" to a Latin cross, which has a private emblem, which has a Woodrow Wilson quote on it, which has a plaque commemorating 49 fallen soldiers, which is surrounded by a Korean War memorial.
Do you really think that to a practicing Christian, a Latin cross does not denote religious significance?
Your Honor, it does. The petitioner does not dispute that the Latin cross has a religious meaning. I think both sides can agree to that. But the question is, as Justice Breyer asks, what is that cross actually being used for? And Justice Rehnquist in Van Orden, in the plurality opinion, noted that something can have both a sectarian and a secular meaning, yet not be a per se violation of the Establishment Clause. The question being, what is it being used for? In Van Orden, the court noted that the Ten Commandments, because of its context, was not being used for sectarian purposes, that it was next to a Korean War memorial, that it was next to a Pearl Harbor memorial. In this case, the memorial is next to a Korean War memorial. This memorial is next to a 9/11 memorial. So
let's talk about next to. When people are driving by, there's only one symbol that they see. Isn't that correct?
No, Your Honor. If you look at Appendix D, roads don't just pass by this cross. Now, petitioner concedes that it is larger than every other monument, but it doesn't...
By a factor of about 100, right?
No, Your Honor, not by a factor of about 100. But just to clarify, I believe the facts on the record show that it's about 4 times larger than the other monuments nearby. And it's also important to note that this monument, for the most part, was built before the other monuments.
I'm looking at Appendix A, which is the shot of the cross. Can
Yes,
you
Your
show
Honor.
me any other monument that can be seen by a passerby from the vantage points of this picture?
Of that specific picture, looking at that monument, no, Your Honor, but if you look at the satellite imagery, this is in a park where roads drive by that park.
I see. So in order to be able to see it, you'd have to be a drone.
I'm sorry, Your Honor.
In order to be able to see it, you'd have to be in a drone.
To see the context.
Your Honor, to clarify, if you walk through the park, you see every other memorial. If you drive in the park, or I should say, if you drive on the highway, that's either south or northwest of the exact point on Appendix D, you can see, for instance, the War of 1812 Memorial. You can see the 9/11 walkway. So this is part of a broader mosaic of non-sectarian presentations.
Well, is your position based at all upon the size of this memorial? I mean, do you object to the size of it?
Your Honor, the size of it does not make it unconstitutional, because I think it's important for this court to look at the construction of the monument at the time it was constructed. This was the First World War. 49 people died in this small community. This is how the community chose to memorialize.
How does that help you, since although the government was not involved, concededly, in the construction of the memorial, it was built by a bunch of Christians who, swore a solemn oath that they were all Christians and they were going to contribute their private resources to memorializing these citizens who had died?
I think an important point for clarification, Your Honor, is that this was primarily funded by the Myron-Tana Veterans Association, that these private organizers who asked for the oath eventually dropped out and weren't able to raise enough money doing what they did. So this other private organization came along and built this. And I think that is the point here, and this gets to what Justice Breyer is trying to describe in Van Orden, which is the court should ask how this is being used, not necessarily whether it could be symbolic.
Well,
No, you're right.
well, is a cross commemorating veterans part of our history in the same way as the Ten Commandments?
It is, Your Honor. Directing your attention to expert testimony that was brought to the Ninth Circuit in the case of Trunk, undisputed expert testimony. The amount of crosses that have been used in war memorials increased in the 19th and 20th century, although they are more the exception than the rule to war memorials in general. However, even in the significant war memorial of Arlington, and this is also in the expert testimony presented in the case of Trunk, there are 3 separate crosses at Arlington as we speak: the Canadian Cross of Lost Freedom, the Mexican-American Cross.
But Jewish soldiers are not buried under a cross. At Arlington, they're buried under a Star of David, are they not?
Your Honor, to clarify, I think that there are both. There are individual crosses that are used on graves in Arlington, but there are also ones that universally recognize all soldiers who died in wars. And that would be, again, the Civil War Cross, the Canadian Cross, and the Mexican-American Cross.
Okay, so historically you're saying we have, as a society, chosen, probably because we were a Christian-dominated society, to use crosses to memorialize fallen heroes. Is it an implication of the Van Orden test that we will more likely than not uphold Latin crosses, but would strike down newer, less historical monuments to the fallen? A Star of David in a median, a sickle in a median, a Muslim symbol in a median?
Your Honor, I think the question is, the answer is yes. The answer is history does matter, but it only matters in the sense of whether or not it causes social discord in the community and whether the community saw that as secular. So, for instance, if this was a Star of David, or this was some type of religious imagery that was symbolic, but also represented something non-sectarian, it would be constitutional. But if this
is there
something,
anything other than a Latin cross that you can think of that meets that test?
as far as religious...
With historical significance, both secular and sacred?
Your Honor, I believe the Ten Commandments could also fit into this analysis and does fit into the analysis in Van Orden. The Ten Commandments, any secular meaning from the Ten Commandments is derived from the fact that Moses received those commandments from God. And even though this cross may have, and we argue does have, significant non-sectarian symbolism as it was used in World War I in Europe, as Chief Justice Roberts noted in the plurality opinion in Buono, that this cross was actually used for non-sectarian purposes. So if evidence
In
on the record-
overwhelmingly Christian countries, right? Countries that actually had Catholicism as their state religion.
Your Honor, that may be true, but this was during World War I, and this was on the battlefield. These were soldiers who were being killed, and to commemorate those soldiers being killed, crosses were put up, and that was a meaning that was given to this cross in World War I, which helps explain why they chose this cross and why they actually put a Myron Tanna Veterans Association symbol on the cross itself.
Well,
Isn't the Van Orden test completely circular? You're basically saying because we did it before, it must be right?
No, Your Honor, it's
Why
not. The history isn't the most important controlling consideration. What it does is it's indicative of the two main questions, the purposes of the Establishment Clause. Does this cause discord in the community? And is the government using this to endorse religion? Now, what we have here is
the fact that we have a lawsuit, discord in the community, we have people who are offended by this, and that's why they have litigated it. So don't we already have discord?
Your Honor, there's no history that before this lawsuit, 90 years and 92 years, there was discord. And even a lawsuit that's not what Justice Breyer is describing as the type of discord. For instance, in the case of Trunk, in the Ninth Circuit, that was something that was hotly contested in the community for 20 years. Something like community discord would be protests, would be op-eds being written in the newspapers, for instance. One lawsuit should not be a reason why this court should view the issue, or is a reason why this court should think that there is significant social discord in the community.
So in order to correct a constitutional wrong, you have to organize a protest?
No, Your Honor, you don't have to organize a protest, but it is indicative of, it helps us understand whether or not this specific monument actually violates the underlying principles. And there is another reason why the 94-year history is important. Under the same reasoning of Marsh and Town of Greece, there are instances in this country where something that could be viewed as religious or has religious connotation through rote repetition loses its religious significance and starts to gain non-sectarian significance, such as the Christmas tree is something that is noted.
Not a religious symbol.
Well, Your Honor, it does represent the birth of Jesus Christ.
No, but it represents a Christmas tree. But a nativity scene, on the other hand, a Christmas tree is a German pagan symbol that's been syncretized. A nativity scene, I think, is what you're grabbing for, and it's hard for me to see how that becomes sectarian.
Well, even in the case of Lynch, where there was a nativity scene that's being talked about, when that was surrounded by other either religious or non-sectarian elements, the court was able to view that in the context that it lied in, which is not endorsing religion, not endorsing the religious enterprise.
Could you just going back a step to the history here? What if the demographics of a community changes over years, over 90 years? How would that affect your view that 90 years matters? In other words, what if the new arrivals have a different attitude than those who lived there 90 years earlier?
If there was significant discord in the community, and there was evidence of that on the record, or intimidation, as Justice Breyer even notes in Van Orden, which didn't exist in Van Orden, then that could be, Petitioner concedes, that could be a reason why such religious imagery could be struck down. But what's important to note is social discord isn't the only reason, or isn't the only factor that this court should look at. The court should also look at, as Justice Breyer instructs, how it's being used. So even something that causes social discord doesn't mean it violates the Establishment Clause, because we also have to look at whether or not it's being used for a non-sectarian purpose.
Mr. Pinchak, what test should we be applying in this case?
Your
There
Honor,
are so many to choose from.
That's correct, Your Honor. The tests in this case are thorny, but this court should not use any mechanical one-size-fits-all.
We should use them all?
No, Your Honor. Van Orden explains all the other tests by using those factors talked about in Justice O'Connor's endorsement test, the coercion test, the Lemon test and the reasonable observer test. All of those factors flow through Van Orden, and instead of having a one strike and you're out test, through Van Orden, Your honors are able to weigh the factors in a fact-specific way to, again, ask, how is this actually being used in this setting? And is this causing social discord in the community?
What's our standard of review?
This is de novo, Your Honor. This is non-deferential.
This is a ruling from a summary judgment motion.
Yes,
correct?
cross motion for summary judgment.
When
So,
we,
go ahead, please.
I'm sorry. I just wanted to ask, well, when we have a case like this, which may be a close call, shouldn't we apply the Constitution with some elasticity so as to sort of give the benefit of the doubt to the families of the fallen veterans who may be offended by this?
Yes, Your Honor. I think that's on point. The question, and I think that goes also to the question of how this is being used. This, again, was symbolic of 49 people dying in this community, in this country's First World War, early in the 20th century. In a close case or a borderline case, this court should err on the side of caution. And as Justice Breyer notes in Van Orden, a remedy of taking this cross down or taking something that's been up in the community for so long down could cause the exact same type of social discord that the Establishment Clause is meant to prevent.
I want to get back to something Judge Kronstadt raised. Again, this is a ruling from a summary judgment motion. If you're saying this is fact-intensive, if there's one disputed material fact here, isn't reversal required?
No, Your Honor, I don't believe the record shows that there are any serious disputes over material fact. We know that where this monument is, we know when it was created, we know who created it, and we know how long it's been there. So that there are no disputes of material fact. This is a question of whether or not it, again, attacks the underlying purposes of the Establishment Clause, social discord, and endorsement of religion.
Just to let you know, counsel, I think you've got about a minute and a half other than your reserved time, so.
Yes, Your Honor. Thank you. But going back to the remedy, Justice Breyer noted that taking this down could cause the same type of social discord. What Respondent is asking for, to the scene of destroying this cross, taking it down, moving it, destroying it by demolition, that would send a message of hostility towards religion in this country that does not exist in this community as it stands right now. That members of the community do not see this as government endorsement.
Well, you say it would send a message of hostility toward religion, and yet the essence of your argument is that this is not a religious symbol. So I've got a problem reconciling those two statements.
And, Your Honor, I think the way best to reconcile it is that if this court puts a ruling down and says, this is religious, this has religious meaning, and because it has religious meaning, it must be torn down, that decision, viewed in context of the reasoning of why this court would strike it down, that would send a message that because this is religious, it must be taken down, and that is the exact type of hostility that the Establishment Clause is not supposed to either condone or be an aid to. Thank you, Your Honor.
Thank you. You will have 1 minute for rebuttal. Mr. Mucciolo. Mr. Mucciolo, I want to start with a question. It seems to me I'm with you 100%. The Latin cross is fundamentally a religious symbol. Isn't it fair to say that in this instance it is being used as an analogy? In the Christian context, it's the symbol of the sacrifice of Jesus. It's being used in an analogous secular way to commemorate the sacrifice of these 46 individuals. Why is that a problem?
Well, Your Honor, as you note, the Latin cross has an unmistakable, nearly 2,000-year history as being a symbol of Christianity, and any secular meaning that might be gleaned from the cross is derivative of the cross's connection to the...
Unquestionably the case, but why is that unconstitutional if it's being used as an analog for something that's clearly secular, the sacrifice of the soldiers during the war?
Your Honor, the question that the court in this analysis addresses is, what effect does this display have on a viewer of this cross? Unlike the Ten Commandments display that was at question in Van Orden, which has an undoubtedly secular, dual secular and religious meaning, as the secular meaning being its representation of a body of law, the religious meaning here far outweighs any secular meaning that could be attributed to it. And the effect that this display would have on an observer would be that of the religious far outweighing this secular.
One of the things you asked for was to saw off the arms and make an obelisk out of this. If this is a religious symbol, wouldn't that cause great dissent if you were to deface it?
Your Honor, this is something that Petitioner alludes to as well, the contention that the remedy itself would be a violation here. Importantly, we unfortunately can't worry about what the reaction might be when we're dealing with a violation of the Establishment Clause. If remedying the violation is itself a violation, we've rendered the Establishment Clause essentially powerless in the face of government favoritism and government aggrandizement. And the clause is intended to prevent against those sorts of things.
But where's the favoritism? The only reason the state is involved in this privately constructed memorial is because it's on a highway median, and the state has, I think we all agree, a legitimate entirely secular purpose in maintaining the highway median and anything that's on it. Correct?
That's correct, Your Honor, and respondents concede that there is a secular purpose that the government has in maintaining this display, that of maintaining highway safety. However,
really, is it highway safety, or isn't the interest in you want the land? Did they really want the cross? They wanted the land so that they could construct highway medians.
My understanding, Your Honor, is that there was a legitimate purpose here in terms of preserving highway safety, based on the facts on the record. However, in addition to looking at the purpose, the subjective purpose of the government in their involvement in this display, we must also look at the objective effect that the display has on observers. And the government's maintenance...
And what's the objective effect that it has on your clients?
Your Honor, our respondents have a spiritual stake at play here. They are members of this community who have been made to feel like outsiders. Because
do they feel the same way when they drive by St. Swithin's in the Field Episcopal Church, which has a large cross on it?
Your Honor, I assume that that's a privately owned church, in which case, no.
They all are. We don't have an established church in this country.
Correct. And so, Your Honor,
so it doesn't offend them to see a cross. It only offends them to see a cross on public property.
Well, Your Honor, the distinction there is that while the effect may be the same, the remedy is simply not able to be had for respondents in such a scenario.
Isn't the issue that they can't avoid when they drive past it seeing it? Isn't that why you have standing?
That's correct, Your Honor. In this case, petitioners are residents of the community who are required to drive by this cross on a regular basis, and every time they do so, they're made to feel like outsiders in this community solely because they don't adhere to a religion that their government has aggrandized above all others.
Mr. Mucciolo, Mr. Pinchak described what he suggests as the appropriate test to be applied. What's your view on that?
Your Honor, it's respondents' contention that if the court reaches the question, they should uphold the Lemon test. However, there's an easier route here. We don't have to apply any rigid test.
So you think the Lemon test should be applied?
Your Honor, if the court feels it necessary to apply a test, however, all of these tests that particularly Petitioner has referenced as well focus on concerns of history and context of the display. That is at the root of the endorsement test, the Lemon test, Van Orden. And when we consider a fact-intensive analysis of those concerns that the court has held to be significant in these cases, we find that they counsel in favor of a finding of unconstitutionality here.
Because?
Your Honor, I turn first to the history of this cross. As mentioned, it has this overarching and overwhelming religious meaning for its 2,000 years. And particularly as we look to the specific history of this cross.
Which I think is what's relevant under any of the tests.
Yes, Your Honor, that's correct. And here we could turn to the memorial pledge that the organizers of this...
That was a private group, though. And that was 30, 40 years before the state became involved, the state became involved at all, right? Do we tar the community with that original and I think Mr. Pinchak said failed effort to put this memorial up?
Well, Your Honor, the cross itself cannot be separated from the religiosity of its organizers. Not only is it...
It says valor, endurance, courage, and devotion. It's a war memorial. Why not?
Your Honor, the overarching and most prominent symbol of this war memorial is the Latin cross. And when we look to the religious meaning of that Latin cross, if anything, it serves to neutralize and undo any of those secular elements that Petitioner might claim are adding secular meaning to the
Sacrifice?
display.
Sacrifice doesn't have a secular meaning when 49 people die in a war?
Your Honor, I think an important distinction here could be made to the creche in Lynch, for example. So in that case, the court looked at a creche scene where there were religious symbols that were proportionately displayed alongside secular symbols. All of those symbols together shared the center of attention, and as a result, it was found to be constitutional because the secular meaning could be inferred to that religious scene as a celebration of a holiday season. Here, however, the religious elements far outweigh these secular elements that Petitioner would point to, and as the court has noted.
I apologize. Please finish your sentence.
Thank you, Your Honor. And I was just going to say that it's this religious element that is most prominently on the minds of a viewer here. It's the clearest aspect of this display. It's religiosity. Many of the secular elements are not clearly visible. Even the MVA's logo that Petitioner points to has to be taken in context of the MVA's religious affiliation. They're an organization that has commenced their meetings with prayers and has held events at the cross that were that included religious aspects like benedictions. And
wasn't the last time that happened many years ago?
Your Honor,
on this record?
Your Honor, I'm not sure when the events ceased. I know that long after the dedication ceremony, there continued to be these memorial services that were imbued with Christianity. It's now been 50 years that the government has been involved, but we can't...
And during that period of time, there haven't been any such meetings, any such events. Isn't that correct? Can you point to one that's in this record?
No, I can't, Your Honor. Again, however, I point to the fact that we can't separate this cross from its history. We look to the cross through the perspective of an observer who is aware of this history.
Sorry. I want to get back to something the Chief Justice suggested earlier. So does your argument depend on people's familiarity with the Christian religion as opposed to a different religion? Imagine you had a 40-foot religious symbol that's important to indigenous people, and does your analysis depend on an understanding Christianity as opposed to a different religion?
Your Honor, if I'm understanding you correctly, are you asking what religion and the reasonable...
I'm asking, does it make a difference that it's a Christian symbol with which most people are familiar with, as opposed to, in our multicultural society, a different religious symbol? And does the validity of it depend, given the historic test in Van Orden, on the community's knowledge?
Not necessarily, Your Honor. I mean, we assume that the person who's being affected by the display is a member of the community, but a religious symbol, and again, this can depend.
So if I understand the judge's question correctly, if a totem, which was a religious symbol to a local Indian tribe, had been placed in the median in 1929 to symbolize the deaths of 49 soldiers, a totem that has sacrifice as part of its legend. Not that I would know that. Her question is...
How do you apply the reasonable observer test?
How do you apply the reasonable observer test? Yes.
Well, the reasonable observer, Your Honor, if we look to, for example, Justice O'Connor's endorsement test, the reasonable observer is deemed aware of the history and context in which the display is found.
So you're assuming that everybody's going to be significantly aware of Christianity, but, I don't know, might not be aware of the indigenous tribal religious customs?
I think a distinction can be made there, Your Honor, because of the continuing relevance of the cross as a religious symbol in society today. And so it is much more well known as representing a religion. And as a result, the effect on observers differs in that case.
Mr. Pinchak addressed a question about whether a cross commemorating veterans is part of our history. What's your view on that?
Your Honor, we don't disagree that the cross does have a secular meaning as representing, as memorializing death here. However, regardless of its connection to history, firstly, no, it does not have a sufficient history linking it to our country as the Ten Commandments did, for example. There's no such long-standing tradition recognizing the Latin cross as a symbol of this country. And for that reason, it wouldn't receive the same special treatment that the Ten Commandments might.
Let's talk a little bit about context. What if it were taken down and moved into the interior of the park with other war memorials? Would that make a difference as to whether or not there was a violation of the Establishment Clause?
Your Honor, it would change the analysis. Context is important. However, the cross still is 4 times larger than any of the other monuments in the park. It outweighs, overshadows each of these other secularizing monuments to the extent that it represents an aggrandizement of religion over these secular symbols.
I believe the record reflects that there are monuments similar to this in many countries around the world commemorating World War I veterans. Does it make sense to you that all these other countries should have a memorial and the U.S. should not?
Your Honor, the United States has a particular the United States has a particular view on how the government and religion should interact. Some of the first people who arrived in this country were religious exiles, and as a result, we have a particular sensitivity to involvement of the government in religion and overlap of those two things, and particularly favoritism of religion by the government. That's the heart of the Establishment Clause, is maintaining government neutrality towards
So you're suggesting we're different than these other countries?
I am, Your Honor. I think that our constitutional history indicates that because of this particular communal knowledge that we have deriving from our founding.
But the statute is essentially passive. It's just sitting there. It's not advocating one thing versus another. I mean, don't we take that into account too?
Your Honor, it's passive in the sense that it's not necessarily doing anything, engaging, but people like respondents are forced to drive by this display just to go about their business every day. And for people who are adherents to that religion, it may not feel like an offense or an injury, but keeping in mind some of the people in this community who aren't of the same religious persuasion as that which the government has aggrandized here, they would feel offended.
You mentioned that if we felt we had to get there, that we should apply Lemon, as the court below did. And what constitutional or prudential principles warrant different treatment for passive monuments under the Establishment Clause as opposed to other kinds of things that have been attacked under the Establishment Clause, invoking Lemon?
Mm-hmm. Your question is, why is Lemon...
Yeah, why are passive monuments different? What's different about them?
Your Honor, the question about passive monuments gets more towards the entanglement prong of Lemon.
That's okay.
And that's correct. And so that's less in question here.
Why are they paying taxes are being paid to maintain this?
That's correct, Your Honor. Respondents would posit that it does constitute excessive entanglement. However, the focus of the analysis would be on the second prong, whether or not the government advances or inhibits religion with their maintenance and display of this symbol.
Does it matter that $200,000 was spent maintaining this object over the years, but apparently none of that was spent maintaining the non-religious elements, the signage?
That is significant, Your Honor. In fact, it indicates that the government is putting those elements second to the religious elements of this display. And in fact, just recently, there was $100,000 put aside towards restoration of this cross. That
But
emphasizes.
isn't that so it won't fall down and hit a passing car?
That's true, Your Honor. However, it is an indication of the neglect that has also been shown towards the secular aspects of this display, where it seems that the religious seem to receive more attention and a greater degree of favoritism in this case.
It's the 40 feet that creates the danger, right?
Your Honor, it's also my
The fact
understanding.
that you have a 40-foot tall piece of stone in a highway median that creates the danger, isn't it?
Your Honor, the fact that there's a 40-foot tall, display is a safety hazard. It's all the more reason that this display should be removed or moved elsewhere. And
Just to let you know that you have 3 minutes.
thank you, Your Honor.
Could you go back just briefly to Justice Peckman's question about moving the monument? Does the record reflect the comparative size of this monument to the ones near it presently, and the comparative sizes of the monuments in Van Orden?
It's my understanding, Your Honor, that in this case, the comparative sizes are that this display is about 40 feet tall compared to the next tallest being 10 feet tall. In Van Orden, my understanding is that the symbols were all relatively of similar size, and in particular, the Ten Commandments display was about 6 feet tall. It was much smaller, much less prominently displayed. That is a significant factor here, the prominence with which the government is displaying this symbol. It's located at a busy highway intersection, one of the busiest in this county. It was built concurrently with the development of that highway, and it was intended for people to see this and see it as a government endorsement of the message which the religious symbol conveyed. Your Honor, I also want to address briefly the point that Petitioner makes, implying that the length of time here and the length of time that the cross has gone unchallenged is somehow indicative of its constitutionality. In this case, however, that is too simplistic an argument, as it implies that a display which violates the Establishment Clause on day one may, over time, at some point, become constitutional. This argument discounts the possibility that there were people in this community who perhaps felt injured by the display, but were intimidated or feared social rebuke, and as a result decided not to raise a constitutional claim. And if the length of time means anything in this case, it is that a constitutional violation has been occurring for 90 years.
Well, no, be fair. If there's been a constitutional violation, it's been for less than 90 years because the state did not become involved with the ownership and the maintenance of this thing until 50 years ago, something like that.
Your Honor.
How do you reconcile your point of view with the Ten Commandment cases? I mean, which I'll concede are all over the place. But how do you differentiate between the Latin cross and the Ten Commandments? Because there are people in the community that would feel the same way about the Ten Commandments as you're describing the Latin cross.
Yes, Your Honor. I see that I have two questions. May I answer, I'll answer the Chief Justice question first?
Sure.
And could you just repeat it for me briefly? I'm sorry.
Actually, why don't you answer Justice Bendick's question?
Sure, Your Honor. So the distinction that can be made there is that the Ten Commandments have been recognized repeatedly as having this dual secular purpose, this dual secular and religious purpose. I see that I'm out of time, Your Honor. May I briefly
I
conclude?
think you should finish answering her question.
That being said, I mean, the Ten Commandments have a special connection to our nation's history as a body of law that influenced the founders. The religious symbolism of the Latin cross has no such secular meaning to outweigh it.
Thank you very much.
Thank you, Your Honor.
Mr. Mucciolo. Pinchak, you have a minute.
Chief Justice McMahon asked the respondent how many years have gone by since the last religious event took place at this memorial. 87. 87 years have gone by, but what has happened throughout those last 87 years at this cross has seen countless other non-sectarian war memorials built around it, including the Korean War, the War of 1812, and the 9/11 memorial.
Mr. Pinchak, can you just answer one question? both the majority and the dissent in the Court of Appeals agreed about the meaning of the reasonable observer test. But they came to different results applying that test. How is that test useful to us when 3 judges, all of whom are reasonable observers, came to different conclusions applying the same test?
Your Honor, that's a problem. It can't be defended. It isn't reasonable. And that's why Van Orden is so important here, because it allows the judges to look at the fact, and I see I'm out of time, briefly.
Please finish answering the question.
The reasonable observer is an in-out test in which the judge decides or can decide what outcome they want and then determines what the reasonable observer knows. Van Orden allows the judges to weigh these factors and give them different weight based off the relevancy to the question of whether or not this attacks the purpose of the Establishment Clause. Thank you.
Thank you. We will take this case under advisement. Ladies and gentlemen, please be seated. First thing I would like to do is to thank you on behalf of all of us for the very warm welcome that we have been given here at Cornell this weekend. It's just been a wonderful weekend. So excited to meet so many students and to hear this amazing oral argument. And I would like to do a shout out to the Moot Court Board. What an extraordinary problem. I've told you all, and I'll tell you publicly, the best bench memo I've ever seen. And an extraordinarily difficult problem for first-year students to have to tackle. It was just argued in the Supreme Court, as I think you know. I've been told that Neil Katyal, who argued on the Mr. Pinchak side, will be here next fall, so you should bend his ear about that argument. If we were privileged to vote tie, I think we would have done it, because you really both did a marvelous job, and I congratulate you both. We all congratulate you both, and I'll let my colleagues speak. But we had to pick a winner. Mr. Pinchak, you are the Langfan Moot Court winner. And Mr. Mucciolo, you are as close a second as it's possible to be. let's just go down the bench. Judge Bendix, what would you like to say to these amazing young people?
First thing I'd say is there's no way I could have done what the two of you did. When I was a first-year student, I would be hiding under the table. So there's no way. So I'm in awe.